essential. So you've got your federal and state laws. How many people know how to get to the laws? No? Really? Okay, well, I want you to know how to. You click right there. That is Louisiana law. It's free. You don't have to. So next time somebody screeches at you, well, that's the law. You go, okay, you know, I know how to get to the law. And can we put these on your website? Is that possible for the Apple website? Because education is so important, guys. So the revised statutes, you go to there. That's all the laws right there. These are all the ones about teachers. Right there in Title 17. We don't have time to go all into it. I want you to know where you can find what you need. All right, let's go to the next one. Local policies. Here's an example, and I just pulled up Monroe City Schools policies. They're online. So you go to Monroe, to get those. Anybody here from Monroe? Okay, you go to Monroe. You know about these? Have you looked at your policies? Oh, I won't put you on the spot. Guys, you've got to know your board policies. And looking back as a 22-year-old, 23-year-old teacher, I didn't know what Austin ISD's policies were. That is not what I was worried about. I was in there trying my hardest to get those kids to learn how to read. And I was spending all of my time doing that. And I left that district not having a clue what their policies were. I look back and think, what was I thinking that I didn't know that? So you must know that. Now what I find interesting in the state of Louisiana is that you do not all have your board policies online. And in order to get some of your board policies, depending on which district you're at, you have to make a public information request. At which point I have been asked to pay up to $1 a page. Some board policies were going to cost me $500, $300. It's all arbitrary. So if you're looking for a piece of legislation, especially with Act 1, if you're not going to publish your policies online for everybody to see easily, then you need to give them freely at no charge to anybody that's requesting them. Because and these policies, some of the books are this big, right? Guess who's keeping them? Like the gatekeeper, the superintendent secretary, right? Like you're going to spend your time going behind this closed door, and reviewing and copying policy. So what I want you to do is make sure that you're very comfortable knowing what your policies are, and then that's where the rules are. Okay, so this is what a lot of districts are using this service. It's expensive, but it's a private service. And once you can put that on your favorites, and that's all the rules. How many people already know where their policies are? You're showing me something I already know. Okay, well, sorry about that. Anyway, the rest of you need to go back to your districts and know those policies so that you'll feel comfortable. All right, so what does Act 1 say? How many of you have read Act 1? How many of you have not read Act 1? Everything you're getting is from the newspapers. Okay, then go read it. It's right here. It's 14 pages. You go to this website. You go to Acts from the 2012. You scroll down. Act 1. The text. Look, there it is. There it is. 14 pages. We're all educated people. We can read, right? And you know where the laws are so you can figure out how to do it. So there's no more, you don't have to be worried or concerned. All right, but I have summarized what it means for you with respect to tenure on this handout. Act 1. If you have tenure by September 1st, 2012, you keep tenure. At first, it was July 1st. And I don't have the inside scoop on why they moved it to September 1st, but somebody said it was because a lot of people would be right there and it ended. And so they would lose it. So if you were in your 4th year about to make it and you were sliding into home, that July 1st deadline was going to be crucial. So they moved it to September 1st. So everybody who has tenure by September 1st, 2012 keeps tenure. Highly effective rating is extremely important now on the evaluation tools that you are hearing about, right? And I'm going to try very hard not to go into things that I don't know anything about with respect to how to get the highly effective and all that. So this is the legalese. All right, in the 2013-2014 school year, which is not this year, it's the next year, concern with respect to that. Now, do you still want to be concerned about your evaluation? Of course, you always do because you're good teachers, right? Of course. All right, in the 2013-2014, an ineffective rating can cause you to lose tenure immediately. Now, I went and looked up and I was like, well, how many different ratings are there? Because in Texas it's different, and I can tell you all about those, but here in Louisiana you use this system. And there's all sorts of different ratings in between highly effective and ineffective. So to the Joe public, highly effective and ineffective are like this. It's like you're good or you're bad, and there's nothing in between. There's lots in between. All right, that it does cause immediate loss of tenure, but there are 3 ways to regain tenure. And that's what I think is very important for the tenured teachers. How many in here will be tenured teachers as of September 1st, 2012? All right, if you're not going to be tenured teachers, I'm still going to speak to you too, so don't worry, because I've got some information you need to know. All right, the first way is that you receive a highly effective rating for 5 years within a 6-year period subsequent to receiving an ineffective rating. Well, I think that one, I mean, personally, let's not hold out for number 1, right? Because that takes 5 years out of 6 years subsequent. So technically speaking, if you look at it exactly like it says, then wouldn't you have to, what if you get 5, you lose your tenure and you have 5 years of highly effective, technically you have to wait another year even before you get tenure again, because it's out of the 6 subsequent. So I mean, there's all sorts of technicalities built in there. I prefer us not to worry with that one. Let's go to number 2. You receive an ineffective rating on the observation portion, plus you receive a highly effective based on the evidence of growth. Now you guys have gone to all these trainings, I'm understanding, right, to understand how this works. So if this is the scenario and this is the reason why you get the ineffective rating, then you are entitled to a second observation within 30 days. There is nothing in the statute that says how you make that request or if it's automatic. So I would like for people to know that if number 2 is the scenario, and we're not talking about this year, we're talking about the next year, right? But if that's the scenario, you need to know to immediately go ask for, in writing preferably, another observation. Don't wait around waiting for that observation to come. Now maybe somebody will figure this out and have some policy and rules in place and some procedures by then, but if they don't, be proactive and go ask. It's also that the observation is given by a team of 3 designees chosen by the superintendent, and that's just all you're left with. So I'm assuming that they have to be trained pursuant to all of the rules that are in place about training people for evaluations. It doesn't say can they be outside of the district, do they have to be in the district. There's so many unanswered questions. Again, if this happens, and again we're talking about not this school year but the next, that might be, if you think for whatever reason, I'm a good teacher, this is just so bizarre, I feel so uncomfortable, I don't know why this is happening, I've had all these great ratings and then boom, it might be time right then to make a phone call. Just a phone call to kind of say, hey, this isn't feeling right. Number 3, the local grievance process. You can grieve your decision. Remember why did I show you how to get to your local policy? Because I can't come in here and tell you what your local policy says because there are too many school districts and each local grievance process looks different. You have to start that grievance process immediately, and the timelines start ticking quickly. Oftentimes they start ticking within 5 days. You have to grieve something within 5 days of its occurrence. So please go back and know what that grievance process is, not because you're a complainer or because you like to complain and complain to, but just to take care of your own self so that you know. In the event that something should happen, I know how to handle it. It's going to be fine, and now I'm going to check that box off and move on to teaching my kids. The grievance process, in this case, is going to be noticed and that opportunity to be heard, but each one, again, is different. The grievance process that Bessie suggests is that it needs to be 15 days after the evaluation, and that there's to be a written response and a meeting between the evaluator and the evaluatee. But it also references that the teachers to pursue the local grievance process. So in this case, and with so much at stake, it really kind of muddies the waters, and hopefully we'll have some better understanding of what that process needs to look like Evaluation, according to BESIC rules, is to be conducted in a fair, objective, and consistent manner. And of course, your specific grievance process matters. Anybody can grieve an evaluation. Those of you who are not tenured, you can grieve yours too. So for reasons that we'll explain in a second, I highly suggest that you know that this is oftentimes where I think now you need to understand that your due process starts here, in my opinion, rather than later with a potential termination. Because at that point, in some circumstances, and because of reasons I'll explain, it may be really, it's already happened. The evidence to support the termination is already in existence. All right. So quickly, the best we can just do this. All right. Prior reasons for removal of a tenured teacher were willful neglect of duty, incompetency, dishonesty, immorality, and being a member of a group that's not allowed in Louisiana. That list, I don't think you guys are going to have to spend a whole lot of time on that, right? Because you're in there doing what you're supposed to do. And when you read the case law that supports these prior things, and this is why people have had this idea in their mind, like tenure, nobody can fire a tenured teacher. Because you've got to be really, really, really bad. That's why. And that is where that sort of idea, I think, in people's heads has come from. Tenure means that you never can be fired, because you've got to do some pretty egregious stuff. And when you look at the case law, it is pretty egregious stuff. All right, they've added now to that list, and it adds poor performance. And that's what is sort of like, oh my word, now poor performance is on the list. Well, how do you prove poor performance? Because y'all are good performing teachers, right? So you don't have to worry about that. But that's where poor performance, do you see where poor performance is a little bit greater than some of these other things? The law states clearly that the evaluation results of ineffective, in and of themselves, are sufficient proof of poor performance. What that means for the lawyers is that all they have to do is take the ineffective rating, and it's a done deal. We don't talk about how hard you worked, and how good your kids were, and how good a teacher you were, because that ineffective rating is an automatic, substantial evidence of poor performance. Is everybody understanding now why our due process starts back at the grievance stage? So, and even if you're the type that says, I just don't want to call Nate, that's what I think you need to understand. You've still got due process though. I absolutely, firmly believe in looking at all this, that it's still there. You just have to jump on the due process train faster. All right, so, because also built into law, it says no termination for an ineffective performance rating until completion of the grievance procedure if a grievance was filed timely. Okay, so do we file a grievance if you get ineffective? Yes. Okay, you're seeing now where your due process is already started at that grievance process. The procedural requirements are that you have to be furnished with a written copy of charges, and this is once the termination begins. You have 7 days to respond, so you still have even more due process after that. You have 7 days to respond, and then the superintendent can terminate. So the superintendent provides the written charges, and then you have 7 days to respond and terminate. The decision then can be appealed. So it's still not over. And this isn't old law, this is new law. So this process is still not over after that. So the superintendent says, I want to fire you, gives it to you in writing, you respond, oh, please don't, I want to appeal. The appeals process states that within 7 days after the superintendent dismisses the teacher, you can request a hearing. So you want to know that you need to, if something should happen, you would request the hearing. The hearing shall be granted. There's no choice in that. And then a tenure hearing panel is formed. And the law states that the only prohibitions are that it can't be an immediate family member, and it can't be a full-time employee of the school system by which the teacher was employed and was under the supervision of the person making the designation. I have spent a long time studying law and trying to understand it. That one's kind of feel like personally that if you were, done in and you have all these highly effective ratings and all of a sudden this random ineffective rating because your son beat out somebody's son on the baseball team, they're saying that it could be for any reason, they could just not like you. I would ask for it to be public then, right? That's a right you have to waive your confidentiality rights. Ask for it to be public. Let's all hear the charges about me that aren't true, because everybody knows that, right? So that's a very, very effective way to handle things when they're just not being done right. It shall begin within 7 business days after the receipt of the request. You can bring in witnesses, you can bring in an attorney or counsel of your choice. There's subpoena power for all witnesses. And then this tenure hearing panel recommends they submit their decision. We don't know who's going to train these people on how they're supposed to write this thing up, right? But they write this decision together, I guess, and they give it to the superintendent. And they say, sure, go for it. Or bad idea, superintendent. They submit that to the superintendent, and then the superintendent has to determine whether he's going to reinstate or not reinstate. And if he elects to not reinstate, he has to notify the teacher in writing of his final termination decision, and then the teacher has 60 days to go to court with that. So all this no more due process is looking a lot different now, isn't it? Then the court would say, is it arbitrary or capricious, and you have all the procedural requirements met, are the findings supported by substantial evidence, and if you're successful with that, then the decision would then be reversed. The teacher would be ordered reinstated or restored to duty and entitled to full pay. If you don't have any tenure, or if you lose it and are not successful in reacquiring it, you can still be terminated, but you still have to have written reasons and an opportunity to respond, and you get 7 days to respond. So in my opinion, you want to use that very wisely as well. And I think I'm running out of time. Am I done? Is it time? What time is it? Keep going. Okay, and just final, your reduction in force, there are to be new RIF policies by September 1st. Those RIF decisions are delegated to the superintendent and to be used when dismissing teachers. Demand, performance, and effectiveness are now supposed to be, as determined by this evaluation, are now supposed to be the reasons used in a RIF. And basically the law says he's to say least effective, next least effective, next least effective. So is that a way that you might need to go ahead, even if you're just dropping a little bit, and you're in an area that might, you have concerns, should you possibly then use the grievance process earlier than 2013, 2014 to grieve something? Now, I am not suggesting that everybody run out and grieve your evaluations. From what I heard earlier today, you guys are good teachers. If you're in this organization, you're out there, you want to understand what you did wrong. If your evaluation is accurate and you're assessing yourself correctly, then don't go grieve every evaluation if it's accurate. But if you felt like it was, for whatever reason, wrongly inaccurate for some reason and had dropped you in rating in a way that was inappropriate, if you have a truly grievable reason for grieving. Does that make sense? All right. No seniority. I'm sorry.
So far, the explanation that you're giving us is for 50% of the evaluation, that part that's done by the administration, the observation. The other 50% of the evaluation is done by the so-called value-added, it's got a few other names, the control.
why you as APPEL members would grieve grieve an evaluation. It's not because you sat there and ate your lunch while the observation was going on and got an ineffective rating because of it, or you're not doing what you're supposed to do. It's because there was a mathematical glitch, or there was a real reason why this rating came in lower than it should have. Let me finish this and I'll have some questions because I don't want us to run over and be kicked out of the room. Again, there's no seniority or tenure, and it sounds like y'all already know a lot of this part. And that again, you still have the right to request a review, notice of review results, and pursue. The superintendent's responsibilities, I think, are pretty important because they're to now, and to be, the superintendent is now responsible for ensuring that state laws are followed. And from what I've seen, I feel like they're sitting ducks. Depending on their relationship with their school board's attorney, which oftentimes what I've seen, that attorney is there for the school board. And then the superintendent, in some cases, they have direct access, immediate access, but in other cases, they don't have the kind of communication and connection that they are going to need to have with an attorney for them and for their staff. Because it's not often the superintendent, it's also oftentimes, depending on the size of the district, is relying on their staff. And so there are a lot of problems inherent in having that superintendent. And I guess what I'm saying is that you could grieve it, if there's a real issue, because there's a lot of room for mistakes and errors within having this person be so responsible. I'm not saying I'm not criticizing it, but I just mean that I'm identifying where I think a need may be. There's holes. And they do need to have communication with an attorney for advice. They cannot terminate for discriminatory reasons, even if you don't have tenure. You can't terminate, an at-will employee can't be terminated for a discriminatory reason. And in Louisiana, these are the things that would be discriminatory reasons. Who is going to help the superintendent make those decisions about whether his decision is defensible? Hopefully, there is somebody, locally in each local area, somebody stepping up and realizing that these things need to be put into place. Louisiana has employment discrimination laws, the Louisiana Commission on Human Rights, and of course, you can complain to them. There are deadlines, and then the EEOC. You can complain to either one if, for whatever reason, you felt like the termination fell into one of these categories as discriminatory. Okay, so, there was a question, and I had you hold on.
Suppose it's just the opposite of your scenario. You said ineffective on the observation and effective on the test scores that came back from the state. Suppose it's opposite. You got a highly effective from your principal in the observation, but the test scores came back and they gave you an ineffective. No, Johnny didn't take care of a kid that night, or didn't get the rest that he should have gotten, didn't eat the meal. What kind of grievance do you have there?
You could still have the right to grieve. Now, I would have to defer. I think you guys have been going into this way more in depth than I have about the value added and what it all means and how it all works. And so if somebody came to me as an attorney and said, hey, I need help, I want to grieve this, I would probably have to, really do my homework and figure out how that works. Where are those rooms for error within the value added system that Louisiana has? And I wouldn't be making something up if I told you where the holes were with that, because I don't know.
It sounds like that's what you could say. You can't give this teacher a good rating and that glitch caused her score to
Possibly. It sounds to me like, though, that there are people in this organization that are already identifying maybe, the little problem areas with that or whatever, and so that's important to know as well.
One, at our school, they're not supposed to have their cell phone unless they have an athletic event or something after school, in which case they're supposed to turn it into the office and keep it at the end of school, but they all have them. And they put them in inappropriate places so that we can't confiscate them. Like they put it down their underpants or into their bra. So if I'm in my classroom and they have this and then they stuff it somewhere that I'm thinking not going, how is that to you?
Well, okay, number one, understand that rarely do I have, this is a special exception, not an exception, a special opportunity for me to speak to teachers, because oftentimes the room's filled with administration. And I'm saying to the administration, don't do that to your teachers. Please don't. Make specific rules with specific consequences that are followed. If you do this, if the cell phones are telling you you can't have Facebook in your private life is a bit, you know, that, I mean, I can see that's not okay. Oh, okay, that is different. And so I'm not telling you that you need to not have Facebook because, you know, I'm just telling you it's so dangerous, it's so gray, so you have to just be very, very, even when you have those confidentiality settings, don't talk about your students on Facebook. I mean, if I was at the board of certification now, I mean, that's where you get all your good stuff, is on Facebook, finding out all this stuff about what people say that they, you know, they're just telling the world.
Wouldn't you advise teachers not to friend their students?
Yeah.
I would.
I would. They should
Yeah,
not friend their
now
students.
understand, we're talking about, you can't, again, this is just like, okay, I'm saying, I don't advise that you get on Facebook and say anything about your class or anything like that. Do I think that schools should be able to tell you you can't have Facebook? That's overreaching. If you do have Facebook, should you friend all your students? No. Can the school tell you? Because then you get these small communities. And I mean, you're teaching half your buddies. And they're mamas. You're best friends with the mamas and the people that are the daddies of the people who you're teaching. So I get all those things. And what I'm up here to tell you is that I don't have any clear answers. It's so gray. For you guys as A+PEL members, be careful. Because when you don't want to go where gray is in the law. Not if you don't want to go to the courtroom. All right. I think I'm majorly over. I appreciate and have a great school year and a great rest of the conference.